Okay, so this session is going to be over the Texas judiciary, and I'm really excited because chapters 9 and 10 are your textbook, are my absolute favorite chapters. So I know that makes me a really big geek, but I find that exciting. Also, it means that we're nearing the end of your course, so you should be excited about that too. Okay, so chapter 9 is really designed to give you an overview of the court system, and then chapter 10 goes more in depth. So if you find that you're having issues with chapter 9, it's pretty important to let me know, because those issues, if you don't get them now, are going to kind of come back to bite you again when it comes to chapter 10. So civil and criminal cases. There are two different types of court cases that an individual or the state can pursue. So civil cases deal primarily with individual or property rights. And in that case, the person who's suing, that person is called the plaintiff. The plaintiff is going to be a private party, so a person or a business. The plaintiff is suing the defendant. The plaintiff is the person who has the burden of proof. What that means is the plaintiff needs to prove their case. Theoretically, the defendant could just sit there and do absolutely nothing. It probably wouldn't be advisable, but they could do that because it's totally up to the plaintiff to prove their case. So the next question becomes, how much do they need to prove their case by? Well, they have to prove their case based on what we call a preponderance of the evidence. That means that when the jury sits and deliberates, they have to think that the plaintiff is more likely right than the defendant. Let's say that the plaintiff wins. What do they get? Well, what they get is a remedy, and that remedy is relief from or compensation for violation of legal rights. Most of the time, what that equates to is money. They're usually getting money. Criminal cases involve a violation of the penal law. So we have a Texas State Penal Code. It's basically just a code that goes through and lists out all of the criminal offenses in the state. So everything ranging from really low-level crimes to really high-level crimes. The state is the party initiating the suit in a criminal case. And the state is going to have the burden of proof to prove that the defendant is guilty of the crime. That guilt has to be proved beyond a reasonable doubt. So beyond a reasonable doubt is going to differ depending on basically whoever it is that's interpreting. Example that I usually use and that I've put in your supplemental video clips is Judge Alex from Headline News. He explains reasonable doubt as this. Imagine that you drove to the office or to the school and you parked in your usual parking spot, and then you walked into classes or work or wherever, and then when you came back out at 5 p.m., your car was in the exact same spot. Most people would say that beyond a reasonable doubt, their car had been parked there all day. But that's not necessarily true, right? In theory, what could have happened is a flatbed pickup truck could have backed up, and they could have slid your car on, and then they could have driven up and down the freeway all day and put it back before you came out. Well, most people would say that's not really reasonable. We think that beyond a reasonable doubt, that car sat there today. But it's up to the individual juror to decide what is or is not reasonable doubt for them. That standard, that burden of proof, you're going to notice is going to be higher in a criminal case than what we see in a civil case. And the reason for that is that the remedy is much harsher in a criminal case. So the remedy could be something that's just like a fine, maybe a low-level fine. It could also be imprisonment, though. So we could confine somebody, or we could give them some form of supervised release, or in really extreme cases that we're going to talk about later on, Texas actually has capital punishment. So we could actually execute somebody for their crime. So we want to make really, really sure in a criminal case that we're convicting the right individual. Okay, so our courts are divided into courts of original jurisdiction and courts of appellate jurisdiction. Courts of original jurisdiction are courts that have the power to try a case that's being heard for the very first time. So if you ever watch Judge Judy, or you watch Law and Order, or you watch any of those types of TV shows, those are courts of original jurisdiction that you're seeing play out. The judge is there overseeing the procedure. So the judge is the person who is ruling on those objections. So you watch Law and Order and you see one of the counsels stand up and say, "Objection, Your Honor," blah, 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 blah. And then the judge either says overruled or sustained, meaning I don't agree with your objection, or yes, I do agree with it. Well, that's the judge overseeing the procedure of the case. The judge is deciding what evidence comes in and what evidence stays out. Generally, it's going to be the jury's job to evaluate the evidence. Now, there is something called a bench trial where you can basically elect to have the judge decide your fate instead. But most of the time, it's going to be the jury who goes in and hears the evidence, weighs it, and makes a decision as to whether, in a criminal case, you're going to be found guilty or not guilty, or in a civil case, whether the plaintiff has met their burden of proof. So those are the courts of original jurisdiction. Courts of appellate jurisdiction are going to be the courts that get to review those lower court decisions. So they're basically checking up on the courts of original jurisdiction to make sure that they're doing their job well. And in order to do this, they only hear very few appeals. What they do is they review lawyers' briefs to decide which cases they actually want to hear and decide. So a brief is basically just a really long written document that each attorney is going to go through and specify all the ways that they think that they're right and that the court was wrong in its rulings, and then they're going to submit it to the court. And the court is going to review those briefs and decide whether or not to call the parties in to hear their arguments further. Now, in a criminal case note, the state does not have the option of appealing a not guilty finding because of this concept that we talk about called double jeopardy. So the concept of double jeopardy is basically that you can't be tried for the same crime when it's the same incidence of that crime that has allegedly occurred. So the idea behind this is we want to make sure that we're only being prosecuted one time. We don't want to open up the situation where potentially what happens is the state gets to try you over and over and over again until they get the result that they want. So double jeopardy is basically a prohibition on a second prosecution for the same offense after acquittal in the first trial. We don't allow that to happen. The defendant can appeal as much as they want. The prosecution doesn't get to. Okay. I want to skip ahead just a couple of slides here for you. Let's go to slide 8. And the reason we're doing this, or slide 9, whichever one you prefer, is not to actually go in to these courts in depth right now, but just like we did in Chapter 7, to kind of give you an overview of where we're going. So down here, you see justice courts and municipal court. And then you've got county court, and then you've got the district court. All of those courts, these are all going to be courts of original jurisdiction. These courts right here, starting with those 14 courts of appeals that you see, moving on up to the Supreme Court and the Court of Criminal Appeals, these are all going to be courts of appellate jurisdiction. Okay, so with that in mind, now let's start talking about these courts. So municipal courts, we'll start at the bottom. Municipal courts and justice of the peace courts are going to be the lowest level courts that we have in the state. Municipal courts have exclusive jurisdiction to try violations of city ordinance, and they're going to handle minor violations of state law. So if your municipality goes in and they pass an ordinance that says all of your dogs have to be vaccinated, or if they say that a particular roadway you can only travel 20 miles per hour on, those are all going to be local ordinances that the municipal court is going to have exclusive jurisdiction over. When we say minor violations of state law, we're talking about things like public intoxication. So things that the state has deemed to be not really good things to do. We don't want you to get intoxicated in public to the point that you can't take care of yourself or are a danger to others, but at the same time aren't huge violations of law. So what we see on the municipal court level is we see the municipal courts handling the lowest level violations of criminal offenses, what we call Class D misdemeanors. So technically when you go in and you speed, or if you were to get arrested for public intoxication, all those things are crimes. Even if they don't end up resulting in an arrest, they're just low-level crimes. So the municipal court is going to be the lowest level court when it comes to criminal offenses. Justice of the Peace Court. They are going to have technical jurisdiction over criminal cases where the fine is less than $500, but honestly, your textbook is kind of out of touch with the world. Really, for the most part, those are being handled over in the municipal court. The municipal court is going to hear those criminal offenses. Here, let's do this. Cross through. Okay, that was my noise for crossing through. So they have exclusive jurisdiction when it comes to criminal offenses with a fine that has an absolute maximum of $500 and no jail time. Or if it's like public intox, we say no jail time because like you're only confined for the amount of time that it takes for you to sober up. Okay, Justice of the Peace Court. We're going to go back. I don't like that because it's not really accurate. This is most of what they do. In these cases, the civil cases where disputes involve less than $10,000, they get to hear those cases. So that, my dogs are playing tug of war. So they're hearing civil disputes, the Judge Judy disputes of the world, that you owe me money for rent, or I think that you have my pet and you shouldn't have my pet because I paid for that pet, and so whatever, low-level disputes. They're hearing all of those. The amount in controversy can't be more than $10,000. And here's the other part of that. In about a year, that amount is actually going to increase quite a bit, which is going to become a big deal here shortly. And we're going to talk about that. Technically, the Justice of the Peace Courts may issue warrants for search and arrest, but most of the time, those warrants for search and arrest in larger municipalities are actually going to be executed by the municipal court judges, which makes sense, right? Because the municipal court judges are going to be the judges who are basically in charge of those lower level criminal offenses, so they're the ones on the criminal side. Okay. Oftentimes, Justice of the Peace Court judges' qualifications and objectivity tend to be questioned. The reason for this is that we elect our Justice of the Peace Court judges, just like we do with most of our judges in the state. However, one big difference for the Justice of the Peace Court judges is that they don't actually have to be licensed attorneys. Yes, I know. Let that sink in for a minute. So they do have to go and take like judicial education classes, but they still didn't go through like a full 3 years of law school and sit for the bar exam. Why is that, you're going to say? Well, the idea behind these Justice of the Peace Courts is that we wanted to make these courts that were really accessible to the people. So we wanted to give people the option of basically going into court to sue their mechanic for $500. Okay, well, if you were to go to like an I want to say an actual court, if you were to go to a court that had stricter rules of evidence and you had to hire an attorney for that, it probably wouldn't be cost effective for you to do that. So this mechanic could go through life just ripping people off left and right for a couple $100 here, $500 there, and never having to account for it. We didn't want that to occur. And so we created these courts that were supposed to be really pretty easily accessible by individuals. Now, the problem with that, of course, is that we have rules of evidence and rules of procedure in our courts for a reason, not just to make it difficult for people. So sometimes the judges sitting in these JP courts, not always, but sometimes they're not maybe the most qualified individuals to be hearing and deciding those cases. So let's pretend that they heard and decided a case and they didn't do it right and you wanted to appeal. Well, your appeal in that case is going to look different than when we talk about appeals generally. Your appeal is actually going to be called something called a de novo trial. What that means is there is no deference being given to the lower court's decision. We're doing the trial all over again at the county court level. Now, most people don't realize this, and so the appeals period runs. But this is technically your right. If you're in the Justice of the Peace Court and you have a judgment that is issued against you, you are allowed to go in, and within 5 days, you're allowed to appeal and ask for a whole new trial again at the county court level. So when your textbook talks about some of the issues that arise from Justice of the Peace Court, that's what they're talking about. Okay, so now this brings us back to that overview that we looked at a minute ago. I want to skip ahead a little bit. Let's look at the county courts next, because the county courts, remember, were going to be the next highest level court for the courts of original jurisdiction. So each of the 254 Texas counties has at least one county court. Most have more. The county judge is going to be elected for a 4-year term and is going to handle those mid-level civil matters and is also going to handle probate proceedings. So let's pause for a minute and talk about what are probate proceedings. Probate proceedings are proceedings where we're trying to figure out who gets mom or dad or grandma or grandpa's stuff when they die. That's kind of morbid, but that's what they do. So somebody's passed away, and we're trying to figure out who gets their stuff. Well, technically, the county court has jurisdiction over that. In larger counties, the county court is going to actually create a little offshoot court. So they're going to go in, and they're going to say, I'm so glad that I found this pencil tool. They're going to go in, and they're going to say, okay, county court, we're really overwhelmed because we're Dallas County or we're Tarrant County. So we're going to go in and we're going to create our own probate court. Not a very easy to use tool. Okay, so that's on the civil side of things. That's like the thinking Judge Judy. Now let's think more law and order. Those county courts also get to hear criminal matters for serious misdemeanors where the punishment is a fine greater than $500 or jail time is less than 1 year. So if it was somebody's first conviction for a DUI, or if somebody was caught with a small amount of marijuana on them, those would be criminal offenses that the county court would handle. Last up, we're going to talk about the district courts. So the district courts are going to be the chief trial courts of the state, of which there are currently 469. What that means is these are the highest level courts of original jurisdiction. They're hearing civil cases, but they're also hearing criminal cases. On the civil case side, it's any matter that exceeds $200. But notice here, there's no ceiling. There's no cap on that. So the $50 million suit, that's being heard in a district court. Now, I want to pause here and remind all of you that we're just going through the Texas court system right now. So remember, there's a whole separate federal court system that's going to be covered in your federal government class, but this is Texas government, so we're just talking about the Texas courts. Okay, so they are hearing the really important civil cases for the most part. You could go and file your low-level $500 mechanics case here, but you're really not likely to because it would take forever to be heard. So they're hearing the really important civil cases. They're also hearing the really important criminal cases. So the things that society considers really bad things to do, like robbery or burglary. They also hear juvenile cases. So in Texas, you are considered a juvenile for most purposes if you are 16 or below. When it comes to criminal offenses, if you are 17, you are considered an adult for criminal sentencing purposes. These district courts have a really heavy caseload. So we've got a lot of really important cases that they're hearing, both on the civil side and the criminal side. And because they're really important cases, it takes longer for them to get all the way through the court system. Those really heavy caseloads result in something called plea bargaining. And plea bargaining is something that you've probably heard referred to. It's just negotiations between the prosecution and the defense to obtain a lighter sentence or other benefits in exchange for a guilty plea by the accused. So maybe the accused is standing trial for first-degree murder charges, and the prosecution goes to the defense, and they say, hey, defense, if your defendant pleads guilty, which could happen, whether or not the defendant is actually guilty, if your defendant pleads guilty, then we will, to manslaughter, then we will only recommend 3 years in prison with probation as opposed to the 10 years that they were facing. And it might be that the defendant goes ahead and takes that plea deal, even if they're not guilty, because they might realize that at trial, even though they're not guilty, maybe there's a lot of evidence that really looks bad. Or maybe they just don't want to roll the dice on something that important, and they figure it's better to lose 3 years than to lose 10 years. So we see a lot of plea bargains happening at the district court level. Okay, those are the courts of original jurisdiction. Now let's talk about the courts of appellate jurisdiction. So we've got those 14 courts of appeals that we talked about before. Those are divided based on geographic regions. They get to hear both civil and criminal cases, and we have 14 of them because they're hearing appeals within their geographic area. So, for example, we're going to have a court of appeals for Fort Worth and for the Dallas area, and we're also going to have one for Beaumont, and we're going to have one for Corpus Christi. So we've got all of these different appellate courts scattered throughout. They're only going to hear a small percentage of those trial court cases. And of that, part of the reason why is we only have a small percentage of trial court cases that are actually being appealed. The reason is that it's exceptionally unlikely that your case, whether it's criminal or civil, is going to be overturned on appeal. All that the appellate courts are looking for is, was there an error as a matter of law? So did evidence come in that shouldn't have come in? Did we really need to change the venue of this trial to another location? Was there some reason that this defendant's trial wasn't fair? They're not looking to figure out whether or not they agree or disagree with the court of original jurisdiction when it comes to the ultimate verdict. Because remember, these appellate courts, all that they're looking at are the briefs that were filed, and if they wanted to hear arguments, the arguments that the attorneys made. They didn't see any of the evidence. They didn't hear any of the witnesses. They didn't get to weigh any of that. So they're not saying whether or not they agree or disagree with the ultimate judgment. They're trying to figure out something along the way. Did that get messed up as a matter of law? And most of the time it didn't. Sometimes someone made a mistake, right? But most of the time they didn't. So that's going to be the first level of appellate court. Well, let's say that you appeal to them and you don't like the decision that they make. If it's a criminal case, your final state court of appellate jurisdiction is going to be the Court of Criminal Appeal. If it's a civil case, your final court of appellate jurisdiction is going to be the Texas Supreme Court. So just like at the very bottom of that court ladder that we talked about, how you saw that bifurcation where the municipal court was going in and they were handling the really low-level criminal offenses, and the Justice of the Peace Court was handling the really low-level civil offenses, we see that same level of bifurcation when it comes to the very top of our Texas state court system, where we've got the Texas Supreme Court handling civil and the Texas Court of Criminal Appeals that's going to be handling the criminal cases. The Court of Criminal Appeals is going to have exclusive jurisdiction over automatic appeals and death penalty cases. So what that means is that most of the time, if you appeal your case, you've got to go to those 14 courts of appeals first. So whichever one is within your geographic region you appeal to. But if we are talking about a death penalty case, then we skip over that appeal and we go straight up to the highest level appellate court. We go to the Texas Court of Criminal Appeals in that instance because, number one, we're on a little bit of a time deadline, and this is really important, so we want to have the most important court in the state hear this. But also, remember how I said there's going to be that separate federal court system? Well, there's probably going to be U.S. constitutional appeals that are going to be made in that case as well. And so we want to give this case enough time to not only work its way through the Texas court system, but also to make its way through the federal court system if necessary. Okay, so the Supreme Court is going to be the final court of appeals in civil and juvenile cases. We deal with juveniles a little bit differently than we do with adults who commit crimes. For the most part, we're going to talk about some exceptions here later on, but for the most part, we tend to see them differently, and we tend to view their punishment in a more civil context than criminal context. So what does the Supreme Court get to do? They have original jurisdiction over issuance of writs. So if you think back to earlier on when we were talking about the Texas Constitution and we talked about those writs of habeas corpus, they're going to be the ones who have original jurisdiction over those writs. They also have conduct of proceedings for involuntary retirement or removal of judges. Sorry, all my dogs are distracting me. Okay, so this is basically where, let's say that a judge took a bribe. Okay, well, it's going to be up to the Supreme Court to decide whether or not that judge should be removed from sitting on the bench. And hopefully they decide yes. But it's up to them. They also have conduct of proceedings for involuntary retirement. So let's say that you've got 100-year-old grandpa on the bench with Alzheimer's. Well, probably we shouldn't have that individual presiding over like death penalty cases, right? But if they don't voluntarily retire, even if they haven't done something like intentionally wrong, they probably still shouldn't serve in that office. So the Texas Supreme Court has the ability to remove them in that instance. Finally, they have the power to establish rules for the administration of justice. That's basically just a really fancy way of saying that they're the ones who are in charge of drafting and creating the rules of procedure and those rules of evidence. So they're the ones who are in charge of really making sure that attorneys are doing the things that they're supposed to be doing while in the courtroom. Okay, we're going to pause here briefly because my dogs are wandering in and out and they're worrying me as to what it is that they're getting into. So we're going to take a really quick break. I will be right back. Puppies, you stay in here. I don't trust you out there on your own. Okay, so Texas Supreme Court. We've got one Chief Justice, and we've got 8 Associate Justices, and their terms are actually going to be for a longer period of time. So they're going to have 6-year terms, and they have that policy-making role that we were talking about previously in that Edgewood versus Kirby. In Edgewood versus Kirby, remember, they're going to have the ability to basically go in and they get to make policy choices, such as what are we going to do to redistribute income in these lower income level school districts so that things are a little bit more fair. Grand jury. Now, probably most of you are familiar with this concept of just a regular jury. A grand jury is only used in a criminal context. So we don't see grand juries when we're talking about a civil context. Grand juries in Texas consist of 12 people who sit in pretrial proceedings, and they determine whether sufficient evidence exists to try an individual and therefore to return an indictment. All that means is the grand jury is just trying to sit there and figure out, could the prosecution ever prove that the defendant was guilty of this offense? So not do we personally think that this individual was guilty, but do we think there's just enough evidence to try this person? Now, for most cases, that's going to be a yes, right? Because that's a pretty low bar. They get to consider all of the evidence. They don't need to worry about how that evidence was obtained. They don't need to worry about whether or not it's ultimately going to be admissible at trial. They can compel testimony from individuals, including the defendant. It's a pretty one-sided deal on the whole. And so it's very unusual for a grand jury to not say, sure, an indictment can issue. So why do we do it? We do it as a check on the government's power, because even the mere allegation of wrongdoing can really damage somebody. So if somebody is ultimately indicted and stands trial for a crime, let's say it's something really serious, like let's say it's capital murder. Somebody could easily pay into the 6 figures on their defense. They would have their name slapped across headlines on the news, on the internet. People would form impressions of them, whether that was right or wrong. It might be difficult for them to obtain employment later on. So that indictment brings really huge consequences. And we don't want the prosecutor to be able to go in and just indict people because they don't like them or they're like their political enemies or something. We want there to be some level of check. So even though most of the time the grand jury is going to be okay with that indictment, we still require that step in the process. Now, notice that the first thing that has to happen is the grand jury has to decide, are we going to issue a true bill or a no bill? So a true bill is basically an indictment that is returned by a grand jury. A no bill is a grand jury's refusal to return an indictment filed by the prosecutor. So, sorry, my dog just sneezed, but it sounded really weird. Okay, so in a no bill situation, that is where the due process rights of the individual are basically going to stop right there because all of the proceedings stop. Because what the grand jury is saying is there's not enough evidence to proceed on this charge. A true bill is where the indictment is issuing. There is enough evidence to proceed. And an indictment is just a formal written accusation that's issued by a grand jury against a party charged with a crime when it has determined that there is sufficient evidence to bring the accused to trial. Now, we probably don't want to get a grand jury together in every case, right? That capital murder case, yeah, probably a good idea. But if we're talking about some really low-level misdemeanor case, remember, grand jury members are just going to be regular members of the public. That's probably going to be a waste of their time and maybe something that we don't want them to really have to do for some really low-level offense. So there's also the possibility for lower-level offenses of something called an information. An information is a written accusation. It's made by the prosecutor against a party charged with a minor crime. It's an alternative to the indictment, and it doesn't involve a grand jury. So for low-level offenses, we allow an exception there. Now, what about when we're talking about a petit jury, or just as most people refer to it, a trial jury? So that's going to be a jury for a criminal or civil trial. That's the jury that we're traditionally thinking of. They're the jury that hear the evidence, weigh it, and ultimately come up with a verdict. County courts have 6-person juries, and district courts have 12-person juries. In order to select a jury panel, we go through this process where we basically select them through a process of elimination. So you have a large number of individuals that get called in for jury duty, unless it's right now when there's COVID-19, and nobody's being called because nobody was showing up. So in those situations, you'd call in this really large jury panel. And from those individuals, the prosecutors and defense attorneys are going to start asking those people questions. Sometimes they ask them questions in written format, and they ask them oral questions. Sometimes it's just oral. It depends on the situation. So what they're trying to do is they're trying to find out information about those prospective jurors. And they're trying to figure out, based on the information that I'm getting, do I think these jurors will be beneficial to me at trial? Meaning, do I think that they're going to side with me, or do I think that they're going to side against me? And so if they think that they're going to side against them, then they're going to try to strike them, or what we call challenge them. So there's 2 different types of challenges. The first is going to be a challenge for cause. And this is a request to a judge that a certain prospective juror not be allowed to serve on the jury for a specific reason, such as bias or knowledge of the case. So challenge for cause situations, there's going to be an unlimited number of those. And the reason for that is that this challenge is basically you saying this individual can't fairly apply the law in this case. So if you had a prospective juror who knew that there was going to be a police officer testifying, and they said, oh, I never believe anything that a police officer said. Okay, well then they're telling you that they're not going to be able to actually weigh the evidence that's presented, because just outright they're saying, I'm not going to listen to this police officer. So that would be a challenge for cause. Or let's say that you have a situation where you're talking to the prospective jurors and one of them says, I think anyone who is indicted for a crime has probably done it, because why else would the police have indicted them? Or why else would the state have indicted them? Well, that's going to be a situation where they're not willing to give the defendant the presumption of innocence, so they can't fairly apply the law. So that's going to be an example of a challenge for cause. It's usually pretty hard to get challenges for cause because usually people are going to express preferences, but they're usually not going to say that they just cannot be fair. Nonetheless, though, in like really high-profile cases like O.J. Simpson or Casey Anthony or any of those that you're thinking of, there's probably going to be a lot of challenges for cause. And we get an unlimited number. So if we go through the first prospective jury panel and every single person gets stricken, then we pull in a new group of people. Because again, that goes to the fairness of the case. A peremptory challenge is going to be different. You're going to have a limited number of those. And that's a challenge made to a prospective juror without being required to give a reason for removal. So the number of such challenges allotted to the prosecution and defense is going to be limited. So here it's not because you think that they can't be fair, but it's for some other reason. Like you think that they're more affluent, and so they're not going to really be able to commiserate with your client who's maybe indigent. Or maybe they have a dad who's a police officer. And so even though they say they can fairly apply the law and that they can listen to all evidence, maybe you still just kind of think in your gut that that individual is going to Sorry, guys. My dog is doing this inverse sneeze, and I think it's just allergies, but it worries me every time he does it. Okay. So it's going to be basically for any reason where you think that they might not be fair. Sorry. Except for you can't do it on the basis of race, gender, or ethnicity. So remember when we were talking about that Hernandez case in Chapter 1? Well, remember, the prosecution went through and they tried to take out all of the Latino jurors just because they were Latino, and the court said, no, you can't do that. Well, same thing here. You don't get to go through and say, I'm going to use my peremptory challenge on this person because they're Hispanic or because they're African American or because they're a woman or whatever else. So that demographic information can't be used when it comes to the selection of a jury panel and those peremptory challenges. Okay. Let's say that the jury convenes, and let's say that they can't come to a unanimous decision. So they can't decide whether or not they agree with the plaintiff or the defense, or they can't agree with the prosecution or the defense. Okay, in that situation, you're going to have something called a hung jury, and that is a jury that is unable to agree on a verdict after a suitable period of deliberation. And the result is usually a mistrial. If it's a mistrial and it's a criminal case, it's up to the state whether or not they want to go back in and prosecute again. Okay, I'm getting super distracted by my puppy dog. So here's what I'm going to do. We're going to take a short break here for just a minute. Let's say it's going to be 5 minutes. So go grab water, check your email, do whatever you need to do for this next 5-minute period. And I'm going to hop back on after that, okay? Okay, so we are back. Sorry, y'all. Trying to work from home is kind of nuts. Okay, so let's go now and let's talk about the different ways the judges can be selected. You're going to see here on this particular picture, you can see that we've got in tan, that kind of tawny color, the partisan elections, and then in the blue color, we have appointive elective, and then in the green, we have nonpartisan, and red, we have appointed. So for these red states, let's start there. Appointed basically just means that depending on the state, either the governor or the legislature is putting individuals into office. We are partisan elections, which means that we have judges who are running based on whether or not they're Republican or Democrat. And largely that's how they end up being elected here. The one exception that we have to this is going to be the municipal court judges. Our municipal court judges are appointed by city council, but all of the rest of our judges are going to be elected. There's also the option for those nonpartisan elections, so where the people are still going in and they're deciding who their judge is going to be, but they're not basing it on their political preference. So they're not voting for somebody based on whether they're a Republican or a Democrat. They're really just voting based on the candidate themselves. Then you're going to see that appointive elective. You're also going to hear that referred to as the merit plan. It's basically a hybrid system. In this hybrid system, you basically, hold on just 1 second. In this hybrid system, you basically have somebody who is being appointed into a position, but then there will be an election that happens, oftentimes after a couple years, in which the voters are asked, do you like this individual and do you want to keep them, or do you not like this individual, and would you like us to get rid of them and appoint somebody else into this position? So it's basically like a hybrid of the two. Those are the different options that are available. We use the partisan elections, which causes some issues, in part because the individuals who are most likely to go in and donate to a campaign that's for judicial office, those are going to be the attorneys who are actually appearing in front of the judge. So that obviously presents a little bit of a conflict of interest there. It also means that we have a lot of people who go out to the polls and they don't know anything about the judges that they're electing. They're just electing them on the basis of whether they're Republican or Democrat, which means that sometimes we're electing judges into those offices when they've never even practiced in that particular area, but just because they were going to be that party's nominee because they knew a bunch of people in that party and they donated a bunch of money. So there are some issues that are raised as a result of the way that we select judges in Texas. The thought process was that we wanted to do it this way because we wanted to make them accountable to the people. So that Brock Turner case that we talked about before, that was the people saying, we do not want this person to serve in judicial office anymore. And so sometimes we think it's a good idea to put that check on judges. Okay, so what do we see in terms of judicial makeup now? We tend to see pretty limited ethnic and racial diversity at all levels of the court. The other area that we tend to see not as much diversity as what we might hope are we tend to not see women in the lower levels of the court. So all those courts of original jurisdictions that we're talking about don't really have equal representation when it comes to women. A lot of people will say, well, then why does it matter? Because we have women at the higher levels and pretty equal representation, so why do we care? Remember, the appeals courts are just looking for those really big goof-ups that made somebody screw up as a matter of law. So they're not the ones that are actually like presiding over the day-to-day operations and verdicts in terms of what happened. So even though we see that diversity at the higher level, it's still concerning that we don't see it at the lower level. Plus, there are a lot fewer appellate courts than there are courts of original jurisdiction. So think back, we know every single county is going to be guaranteed to have at least one county court. So that's going to be 254. Remember, we've got over 400 district courts in the state. So just that alone is obviously going to far outpace what we see in the appellate court, which are based on those 14 regional courts and then the 2 highest level appellate courts. This graph is really just designed to show you that we have by far a disproportionate number of Anglo judges in Texas. We also have a pretty large disparity when it comes to male versus female. So that's going to be Chapter 9. Let me know if you have questions over anything with that. Like I said, Chapter 10 is going to build to some extent on what we learned here in Chapter 9. So if you have questions over Chapter 9, please let me know so that we can get those figured out and cleared up before we move on to Chapter 10. All right, thanks, y'all.